Welcome everyone to Employer Compliance Guide to the CAA's No Gag Clause and Attestation Requirements. Thank you all so much for joining us. Please send questions through the Q&A today. We will try our best to answer all of your questions, but if for whatever reason we are unable to get to your question today, please email learning@nfp.com. Today's presentation is being recorded and will be distributed in the coming days. At this time, I'd like to hand over the call to Chase Cannon, Senior Vice President and Deputy Chief Compliance Officer of Legal and Compliance at NFP. Chase, the floor is yours.
Thank you, Amber, and thank you everybody for joining us today for this webinar on the gag clause prohibition and attestation requirements of the CAA. We're really excited to be here on this webinar for you. We know it's a busy time of year for all employers, and we know you have lots of things on your schedules to get done. So we're hoping that we can be helpful for you today as we talk about and educate you and walk you through this requirement that is new for this year. At least the attestation part of this is new, and as we know, it's a big challenge. And so we're grateful that you're here. Hopefully this is helpful. We have additional resources that are either in your hands or can be in your hands, including an employer guide on how to walk through this, and we'll be walking through it as well. And so we'll share those as well, but I did want to talk a little bit about, I'm Chase Cannon. As a quick intro, I lead our benefits compliance practice here at NFP across the country. And I've been with NFP for about 13 years. And so I'm super excited to be here with Carol Wood and Heidi Cottle. Carol is an attorney on the benefits compliance team here and has significant experience in all things benefits compliance. And we're grateful for her. She's been about eyeball deep, if not deeper, on this CAA and transparency rules since they came out, and is really our expert here at NFP on that. Heidi is in a slightly different role in cost containment, developing strategies for clients on cost containment. She also works on the policy side as an advocate and is working to bring market solutions to employers as well. And so I'm really just going to be moderating the call today, and it will be Carol and Heidi who you'll be hearing the most from. But we're all here. We also have the rest of the benefits compliance team here to answer any questions and to support. So again, feel free to send us those questions. We do have our standard disclaimer here that the following is intended to be used for general guidance purposes only. It's not intended to constitute tax or legal advice. Any question regarding application of the law should be addressed to client, legal, or tax counsel. That would be your attorney. The information is current as of September 28th, 2023, which is today. Normally, this is our standard disclosure or a disclaimer, and we kind of move through it quickly. I wanted to pause here really quickly, though. For this issue in particular, and with other issues that are coming up through, we're going to say this term CAA, that's the Consolidated Appropriations Act. And that was the law in 2021 that is really aimed at some of these transparency rules and is really an interesting law that has great intent to try and help facilitate more information in the marketplace and to help you as the employer plan sponsor have better information and more pricing information and more information to make better decisions about your plan. And the goal there is to try and help with costs overall. But what that law has done is introduce some requirements that create a little bit of awkwardness that wasn't maybe as obvious before. At least employers weren't put in this situation that they're starting to be put in more and more. And that position is that there's a little bit more going on, perhaps from a legal perspective. We're going to talk today about this gag clause prohibition requirement that requires review of contracts. And that is an area where legal or tax counsel is going to be necessary if you're not comfortable doing that. And we'll talk a little bit about our role here. But I just wanted to pause and highlight the increasing challenge that employers are having with these new laws. And that challenge is necessitating or creating a newer and more prominent need to have outside counsel available to help. And so our role is really, again, to educate and guide, but we can't give specific answers, partly because it's contractual review, partly because there's no specific guidance, and every situation presents a different answer or a different approach. So we're here to do our best, and we're going to walk through this at a high level. I just wanted to highlight that and highlight it in the broader context of these several different laws, not just the gag clause that we're going to talk about today. Our agenda slide here, we're going to go through the basics and background of what is a gag clause, what is the prohibition. We're going to go through the types of plans that you need to worry about this requirement. And we have an employer action plan, which I know is going to be the most popular part because you're going to be wanting to know what to do here as far as steps to take anyway. We'll walk through the NFP resources and our role, and we'll get into this attestation of compliance requirement, and then some key takeaways at the end. We will talk briefly about a different requirement that's in the same vein here, the self-service tool for TIC. That's transparency and coverage. And then we'll be answering your questions throughout. I did want to say here really quick before I turn it over to Carol to get us started on the background, that there is, we're going to go through everything that we've learned on this and everything we've gleaned. We've spent a lot of time here going through everything we can, but CMS is also doing a webinar later today, and we will take any clarifications that come out of that webinar. We'll have our whole team on that, and we will include any clarifications in our follow-up materials. And then the other thing I wanted to say really quickly here, we will be talking a little bit differently when it comes to a fully insured plan. If you're sponsoring a fully insured plan, your obligations and your challenges here will be a little bit different than a self-insured plan. And so we're going to highlight those. We are going to do that throughout the presentation. And so hopefully that will help sort of clarify the different roles based on whether you sponsor a fully insured plan versus a self-insured plan. And sometimes if you have a fully insured plan, you might have part of it or an add-on that is a self-insured plan. So we want to pay attention and not just say, hey, if you're fully insured, don't worry about this, but we'll get to those parts. I just wanted to say that up front. Like some of these other requirements, fully insured plans might have a little bit easier route here. But I'm going to turn it over to Carol to jump right in with the basics and background here.
Thank you very much, Chase. That was a great overview and introduction, and welcome everybody. So yeah, let's start out just with the very basics. What is a gag clause, and what is the CAA gag clause prohibition? So in the healthcare context, a gag clause refers to a contract term that restricts information that a group health plan or insurer can make available to another party. Specifically, the CAA prohibits plans or insurers from entering agreements offering access to a healthcare provider network that restrict, first, the disclosure of provider-specific cost or quality of care information to the plan sponsor or participants, the plan or insurer's electronic access to de-identified claim information for privacy regulations, and sharing this information with a business associate. And we're going to delve deeper into what all of this means momentarily. An example of a prohibited gag clause is a TPA, which would include an ASI or independent TPA contract provision, stating that a plan cannot disclose provider reimbursement rates to participants because the TPA considers those rates to be proprietary. Additionally, the CAA requires plans and insurers to annually submit an attestation of compliance with this prohibition. When is the prohibition effective, and when is that first attestation due? The gag clause prohibition took effect on December 27, 2020. That was actually the enactment date of the CAA. And there was some confusion regarding this initially. It was a provision without a date. We assume that it takes effect immediately. However, the agencies, meaning the DOL, HHS, and IRS, did release an FAQ, I believe it was in August of 2021, confirming that this provision was, quote unquote, self-implementing. So this means that applicable contracts that are entered or renewed since this date must be compliant. And we did not receive any additional guidance. There was an expectation that maybe in early 2022, we'd receive more information on the attestation. However, that was not the case. So plans and insurers and employers are all expected to operate on good faith compliance, a reasonable interpretation of the law. Then finally, in February of this year, the agencies released FAQs explaining the prohibition and for the purpose of promoting compliance. And they also provided instructions for the submission of the compliance attestations. And according to these FAQs, the first gag clause prohibition compliance attestation, quite a mouthful, is due by December 31st of this year. And that covers the period since the CAA's enactment, December 27, 2020, through the date of attestation. And then going forward, subsequent attestations covering the period since your last attestation is due by December 31st of each year thereafter. And I do want to stop here and just point out that this retroactive effect is indeed going to be a challenge.
Right.
I think that's going to be one of the biggest challenges for many employers because it's not just a matter of making sure your contracts going forward that you're entering into are compliant, but making sure those past contracts are, when maybe this issue wasn't, in the front of your mind when you were reviewing contracts. So that's going to be a challenge. We have reached out to CMS on that, and I think they're aware of the practical challenges of trying to, let's say, amend a previous contract that's already terminated. So they're aware of that. Hopefully we'll receive some additional guidance from them. I do want to mention that their posture at this point seems to be good faith compliance and really helping employers. We found them very helpful with questions. So you may, if you run into situations, you want to even just reach out to them directly. I think they recognize some of the challenges of this particular provision.
Yeah, that's right.
Right, so why did Congress enact the prohibition in the first place? And I think Chase touched on this initially. And one, I think they were looking at both the plan and the participants as consumers, really. And they were concerned about sharply rising healthcare prices and the lack of information that was available for both plans and participants to make informed healthcare choices. So part of the reason for the gag clause prohibition was to remove some of the barriers that prevents access to information about healthcare costs and quality of care information, so plans and participants could better evaluate healthcare options and make cost-conscious decisions. As you know, it's one of the many provisions under the CAA and Transparency and Coverage Rule that are designed to promote greater transparency in healthcare pricing. So the goal over the long term is that a more competitive marketplace would be created by people having access to more information. They'll demand lower prices. This will narrow price dispersions in particular markets, and that this will put downward pressure on prices. So hopefully that will lower the overall healthcare costs. Of course, many of you have seen rises in premiums and say, well, this goal has not yet been realized, and we can appreciate that. There are countervailing factors now. Inflation is one of them, but hopefully it will have an impact. I think we're just beginning to see enforcement also on some of these requirements. So it remains to be seen.
Right.
And then the other reason that Congress enacted the gag clause prohibition was more looking at the role of the employer as a plan fiduciary, a plan sponsor, and needing access to certain information to fulfill their plan administrative roles. And this would be a fiduciary duty, as you know, under ERISA, to ensure that the plan assets are administered prudently and solely in the interest of participants, to monitor the performance of plan service providers, to make sure they're performing their obligations under the service agreement, and also to verify that service providers' compensation is reasonable. And that's really always been the case. It's just been more highlighted by another another CAA provision really requiring those compensation disclosures that we've had in the retirement side of the business for years, but that's been newer on the health and welfare side, the healthcare side. So to fulfill their duties, we recognize that plans need access to provider reimbursement rates and de-identified claims information, and the ability to share this information with business associates. It's particularly important for self-insured plans where the employer, they're typically the plan administrator, assumes greater financial responsibility and a higher level of fiduciary obligations. If these gag clauses are prohibited, should all contracts be compliant now? Despite passage of the CAA 3 years ago, some service provider contracts still include these prohibited gag clauses. As I mentioned earlier, until recently, there really hasn't been adequate focus on the CAA provision, as employers, insurers, and everyone in the industry really has been struggling to meet these other CAA and TIC deadlines. And I suppose that's something of a rationalization for all of us. But there's some truth to that. I just think there hasn't been a focus, there hasn't been guidance. And now that we have these FAQs and this deadline, upcoming deadline, we're all looking at it a little more closely. But it is important to be aware of the CAA requirements and to address any concerning contract provisions. And this is true not only just for the CAA compliance purposes, but to ensure that you as the plan will have access to information such as the de-identified claims data and provider details with associated costs, should you need it, should you want to engage somebody in a cost analysis like similar to the work that Heidi does. Unfortunately, in some cases it may not just be inadvertence, but there has been some resistance in the industry to compliance and providing information to plan sponsors upon request. I won't get into the details, but there are some cases pending. Many of them are just at initial stages, so we really can't draw conclusions from them yet. But basically, work plans are indicating they've requested information that they need to fulfill their obligations to the plan, and it hasn't been disclosed to them as required by law. So these are developments that we'll be monitoring, but they underscore the importance of making sure that you have access to that data. These laws are really to your benefit. They're really to the plan's benefit, and that's important to keep in mind.
Yeah, really important to highlight those points, right? This is really to help make better decisions around the plan, which is good for the plan and the plan sponsor, meaning the business or the employer that's sponsoring that plan, and then also to help control costs. And so as we keep those goals in mind, I think it helps soften the blow of some of the compliance that's being placed here. Really great question came in asking, why is it the companies that are, the businesses that are being asked to police these contracts? And that's the frustration, right? This is how the law was written, and it's a frustrating aspect of it. But speak to that.
Right. It's a fantastic question. We've spoken about this as well, and part of it, and I think this goes beyond the CAA gag clause, is that the regulators really don't have the ability to regulate the TPAs.
Mm-hmm.
They can. There's regulation of insurers, but not of TPAs. And they're probably often the best party. It's probably their template contract in many places. Beyond this, we see it with the mental health parity analysis. They're probably in the best position to fulfill the CAA obligations, but the regulators don't have the authority over them. So instead, they can regulate the plans,
mm-hmm.
And that's the way they're approaching it, because they really don't have another option. So I think that's one of the main reasons, and maybe we'll see some changes in that. But for now, again, this is one that's really in the employer's interest to fulfill.
Yeah. So that was a little bit of what I was trying to highlight up front, is just this new awkward dynamic that the laws, particularly the CAA, we're talking about the gag clause today, but it's highlighted in other areas here, really put the employer in a tough spot. And unfortunately, it's just the way the law is written. But that's the employer is the plan sponsor, and they're asking the plan to do this. So we wish we could talk to Aubrey. Oh yeah, go ahead, Heidi. What are your thoughts here?
Yeah, so just a couple of comments around that as Chase and Carol describe what the law states. In practice, just a couple of tactical things to be aware of as you as plan sponsors, because this is your group health plan, as Chase stated. And as a plan sponsor of a group health plan, that then puts you in the position under ERISA and then more broadly now under CAA as fiduciary of that plan and oversight of that plan. So part of what we're seeing in these contracts, though, is that, and let's just take a practical experience on a self-insured plan, for example, as what Carol and Chase stated, is that kind of the process is a little bit different, but the self-funded employer, whether they are actually doing an administrative services only with a carrier and you're just self-funding, that it puts you kind of into a different role. And you'll end up signing an administrative agreement that doesn't have any gag clauses in it, but it will refer to like a network agreement. And in that network agreement, if you're not looking at that network agreement, there may be gag clauses in that network agreement. Additionally, what we have found is that it's not so much in those administrative agreements that we're seeing some of what we would consider problematic with gag clauses. It's those secondary agreements, meaning that even when we have asked as a business associate for the plan for additional data, that then we see confidentiality agreements and limited use agreements, and which are based on the limited guidance we've received are in essence gag clauses. So I think that's something as you get to the tactical level, just to be aware of, that it's not just the administrative agreements, it's some of these other complementary agreements that we see some of the problems.
Yes, great point. And if you're thinking already that this sounds like a lot and there's too many agreements, we are going to walk through this. So I think that's a really good segue into our next section, which is really focused on the specific requirements and the applicability. This will capture which plan types we're talking about as well.
Yes. Thank you. Thank you, Heidi and Chase. What specifically does the CAA prohibit? Let's review this again in more detail. Yeah, I think this is a lot of words to people, so let's try to break it down a little more so we can understand what information plans should have access to. So the prohibition applies to agreements. If the CAA prohibits group health plans and insurers from entering into agreements with healthcare providers, TPAs, or any other service providers offering network access that include language that would directly or indirectly restrict the disclosure of provider-specific cost or quality of care information, and this is to the plan sponsor, participants, beneficiaries, or those eligible to become participants. And we're talking about provider-specific cost information. This would be the network rates, and it should sound familiar to many of you because this was required to be released under the Transparency and Coverage Rule. Machine readable files, our in-network rates, out-of-network allowed amounts, right? Sounds very familiar. So there's really not a reason to restrict access to this. You know, arguably this is already public, if not in an easily readable format for individuals. The quality of care information that measures healthcare in terms of effectiveness, efficiency, and a number of other factors. So this needs to be available. And it has to be available so it can even be used in a participant tool. And we'll be discussing the Internet self-service tool under the Transparency and Coverage Rule. So participants as well as the plan sponsor would need to have access to this information. And the second prong here, there can be language that restricts electronic access to de-identified claims and encounter information or data, including very specific financial information. So the plan would need to have access to that. And Heidi, I'm going to let you jump in and just explain why having access to de-identified claims and encounter information is so important, especially if a plan wants to do, let's say, a cost analysis.
Yeah, and thanks, Carol. So a couple of differences that I'll distinguish here between fully insured and self-insured or self-funded plans. Fully insured, a lot of the carriers will restrict, claims utilization information based on the size of the client because of HIPAA privacy rights. But in a self-funded plan, that the employer or the plan sponsor, as well as the business associate, does now have access to de-identified claims. And de-identified claims means that, we're not identifying who the member is. We're just identifying information about who the provider is, like an NPI or National Provider Identifier, which is information specific to the provider. It's like their social security number. And information about, where the service was rendered, what the, procedural codes are, like DRGs and CPT codes, so that from a data analytics standpoint, now that we have real time what the actual cost is, meaning that the law now basically says that they must post in these machine readable files what the allowed amount is, which is basically the gross minus discount is allowed. And so prior to any benefit, whether deductibles, etc., we now have the lowest common denominator that we can evaluate from a data analytics standpoint. So that now empowers you as the plan sponsor to do more gap analysis, meaning, is there a DEIB access problem in your plan? Do you need to, are there gaps in care? So it really does provide visibility to where you can support your plan participants in a totally different way and in advance of care, which is the unique part of this, that not only is the data real time, meaning that you can see the cost, but it should be available in advance of care to the plan participant as the consumer. So that's really kind of the information from a de-identified standpoint that's being requested in applicability to these new transparency rules. Thanks, Carol.
Oh, great. That was a great explanation, Heidi. Thank you. And then the third prong is that there can be restrictions from sharing this information, from sharing the information in 1 and 2 with a business associate consistent with applicable privacy regulations. However, service provider contracts can include reasonable restrictions on the public disclosure of certain information. First, as I mentioned earlier, that assumes the information isn't already public, and then arguably it's no longer confidential information.
Right.
Carol, one comment I would make is that we are still seeing, and I would reference back to a comment that you made about that there continues to be a little bit of pushback, that as we've gone out and requested some of this utilization data, etc., we are still getting some resistance in being able to get access to this information in somewhat of what I would say a complete data set as prescribed by these new regulations. So we are trying to be as patient as we possibly can, but in the interest of the plan sponsor and under these new guidelines, in practice, and what we're seeing out there is we're still seeing some resistance. And just as a heads up to the plan sponsors that, it may require a little bit more intervention and support of these new regulations to be able to get this data released.
Right. Thanks, Heidi.
Thanks, Heidi. Okay, so which benefits, we're going to move on here, are subject to the gag clause prohibition and attestation. The prohibition and attestation apply to both fully insured and self-insured plans, including partially self-insured plans, group health plans, and insurers offering group or individual coverage. So the group health plans would include, but not be limited to, your major medical plans, prescription drug plans, and pharmacy benefit plans. And then point solution programs that are group health plans must also comply unless an exception applies. So these are some of your add-on benefits. example, fertility benefits, there's a number of them. And there would need to be a determination made if it's an accepted benefit or not. And we do have a publication on that. Should you have any question about that, or one in fact that Chase wrote that really explains the requirements and what goes into determining if you have a benefit that's a group health plan and which laws apply. The requirements, they apply to your state and local government plans, church plans, grandfathered and grandmothered plans. The exceptions here would include accepted benefits, short-term limited duration insurance, limited scope dental and vision plans, long-term care plans, certain hospital or other fixed indemnity insurance, specific disease or illness insurance, and accident, disability, and workers' compensation benefits. CMS has also informally indicated that the attestation requirement does not apply to retiree-only plans. That would be consistent with our pharmacy benefit reporting. And additionally, the agency said they're not enforcing the requirements for HRAs or health FSAs. So those account-based plans, there's no enforcement there either. They're not required to test. This is just a list from the CMS instructions, really outlining what we've just discussed. Can an insured, TPA, or other service provider attest for a group health plan? Well, for fully insured plans, both the group health plan and insurer are subject to the requirements, including attestation. However, if the insurer agrees to attest on behalf of a fully insured plan, the agency guidance provides that the fully insured plan can rely on the insurer's attestation that their provider contracts are compliant. In such case, the carrier is accepting responsibility for the attestation, and at least with respect to that particular contract, the employer does not need to take further action. I mean, this is a little confusing the way it was written. We're saying both are subject to the requirements. However, so if you do have an insurer that's saying, we're willing to attest not just for ourselves, but on behalf of the plan, and I think many are, then they can attest for the plan and the employer is relieved of that obligation. For your self-insured plans, of course, it's a different story. So your self-insured, fully and partially self-insured plans, they can satisfy the attestation requirement by entering a written agreement under which a TPA or the service provider agrees to attest on the plan's behalf. However, the legal obligation to comply remains with the plan. And I think this is very similar to what we've seen with other CAA provisions with self-insured plans. They can enter these written agreements with TPAs and other service providers to provide assistance, but ultimately the obligation for compliance still remains with the plan.
Yeah, and that's kind of what I was trying to highlight up front, is that there's a little bit easier path here for fully insured plans. We have seen a lot of carriers saying that they will do this attestation that helps on the fully insured side, but self-insured generally has a little bit more. But that helps us walk in, and we'll highlight this distinction as we go into the employer action plan. So this is really trying to outline what employers actually need to do.
Sure, and this is to kind of bridge the gap, because we in the absence of guidance, how does an employer get to this attestation stage? How do they make sure their contracts are compliant? So employers are going to need to establish procedures to review their service provider contracts and identify and address any potentially problematic provisions. Importantly, this process is going to need to be conducted not only to meet our imminent December 31st deadline, but also each time a service provider contract is entered or renewed. So this is going to be an ongoing obligation. Put it on your calendars going forward. You do need to look at it that way. The process involves the analysis of precise contract terms, and may involve communication with service providers to modify contract language. Accordingly, it's generally advisable for plans to engage experienced legal counsel in the contract review and negotiation process. We emphasize here that involving a legal professional can be beneficial for the plan and the employer for reasons extending well beyond our gag clauses. Right. We know there's a lot of provisions in these contracts that may go to items like indemnification, limitations of liability, And that's really going to be, there are limits specific to the employer, and your, attorney advocating and looking out for you. With respect to those contract provisions is important. So I think that's really something you want to consider. We always hear, of course, we understand there's a cost to that. And some of these hourly rates, we joke and say, maybe we're in the wrong business here. But if you look at that and the benefits of it, really for a contract that maybe for 1 or 2 years, it may be a really worthwhile expense.
Right.
In any case, NFP brokers and consultants can help to educate employers about the prohibition, but we just need to emphasize again here that we cannot provide legal services or advise whether any particular contract is compliant. Okay, so generally, what would this process look like? I think an employer, to break it down here, they're going to have to first determine, well, which benefits are these group health plans that are even subject to the gag clause prohibition. And for some employees, it may be simple. Maybe they just have that group medical plan, the prescription drug plan as well. For others, the applicable plans may include pharmacy benefits, other carve-out benefits that don't qualify as accepted benefits, and therefore they're going to be brought into the requirements. So employers would need to carefully review each benefit offering to ensure they identify all the applicable plans. And again, we emphasize here that if an insurer has agreed to a test on behalf of that fully insured plan, the sponsoring employer would not need to take further action with respect to that particular contract. They would need to just make sure they don't have any other plans that may be subject to the rules.
All right. So we identify the plans, and then
we're going to have to locate the contracts that relate to each of those plans that were identified. So normally we're going to have some type of primary agreement, either with the carrier, TPA, pharmacy benefit manager, or other service provider, but by all different names, right? Insurance contracts, network agreements, TPA agreements, administrative services agreements. Then in some cases, and there's many other names, in some cases the parties are going to enter additional contracts, including non-disclosure agreements and confidentiality agreements. I'll just mention here from my own personal review of contracts for NFP, those non-disclosure and confidentiality agreements can be particularly problematic with respect to gag clauses. So that's really something to keep an eye on. These agreements may be modified or supplemented with amendments or addendums. So the employers would need to gather all of these contracts for their review purposes. And we emphasize all of them since December 27, 2020.
right. We talked a little bit about that retroactive challenge, but also where the regulators might be thinking how they're going to be enforcing this. So.
Okay, this is the step now that really gets into the contract review, and where we emphasize again engaging your counsel. So reviewing each applicable contract for problematic gag clauses. Now, each contract is unique, and they have provisions that have to be reviewed in the context of the entire agreement. So this prohibited gag clause language is going to vary. It encompasses many forms. Examples of problematic or potentially problematic provisions would be, as you mentioned earlier, a provision that the plan cannot disclose provider rates to participants or beneficiaries because the TPA considers those rates proprietary. Also, a provision that specifies the plan sponsor's access to provider-specific cost or quality of care information is at the TPA's discretion. A requirement that pricing information fees and network discounts be only used for plan administrative purposes without defining that term. If the information is already public, your network rates, it's not clear what the restriction would be. So you want to have a broad definition to make sure it can be used for the purposes you need it. A provision restricting the plan from using their de-identified claims data or network rates for plan benchmarking or during an RFP. I'd emphasize the importance of that information for cost analysis purposes. A requirement that the plan obtain additional written consent from the service provider before sharing network rate information with a business associate. Obviously, you need to comply with privacy rules, have your BA in place, but sometimes these agreements try to impose unnecessary restrictions beyond the privacy rules.
So, Carol, you mentioned earlier in the presentation that we're talking about a good faith process right now because there is such limited guidance. If an employer either directly or through the business associate requests the information from the ASO or the TPA and they're not willing to release it, or they just say, we're not going to release it, they don't give any reasons, what is kind of the prescriptive, you shared, go ahead and ask for it, etc. Is documentation of at least the process of going through it, asking, requesting for it, is that at this point, not that you can say, oh, it's sufficient, but is that the prescriptive way of doing it? Make sure you ask and then document.
And we're going to get to that momentarily. I think, yeah, we're going to get to that in the next slide. A few points though I just made before we do, is that this exercise that we're talking about here is really about the contract language. And we're going to get to the steps in documentation, the importance of documentation. But one thing I point out is that if your contract is compliant and then down the line you request data and the party you're working with doesn't comply with the contract, that doesn't prevent you from attesting, or maybe you're going through that now. CMS has I posed that question to them, and they're kind of, this is really about the contract language. You really have an operational failure, maybe it's a breach of the contract even if the TPA isn't complying, but our focus here is getting the language in order. So just to continue here, with the reviewing of the contract language, sometimes it's not an obvious provision. So as we talked about before, what can the business associate do with it? We don't want a purpose defined so narrowly beyond the privacy rules. And some folks have asked, like, if a catch-all provision invalidating any contract, a provision that's not compliant with laws, or even saying not compliant with CAA Gag Clause prohibition would suffice. And we really don't have guidance on that. I look at it as Congress having a lot of lawyers and being aware of those standardized provisions in contracts and still requiring the removal of the gag clauses. We really don't have an answer on that. But I think it's your interest to make sure those gag clauses are removed, even if you have a sort of a catch-all provision in your contracts too, that both parties will comply with applicable laws, and any provisions deemed contrary to law will be null and void. It's good to have that too, but still remove those gag clauses. So if you do find a gag clause, obviously you want to reach out to the service provider and request that it be removed, and hopefully they'll be responsive to that. If that's not the case, as Heidi was alluding to, we've provided in our employer guide, some of you may have received a sample letter, and you should work with your counsel on how you specifically want to word that. But it's always important for purposes of ERISA to document your steps. And this also ensures the letter that it's really getting to the proper party with your TPA or service provider, and maybe not getting lost with somebody who's not, who doesn't understand the legal importance. If the service provider removes the gag clause, hopefully that's the case, then the employer can proceed to the attestation. Now, if they haven't, to the next slide there's another step, and this is just a sample of a letter to requesting that the language be removed. If you don't have a cooperative, service provider, then there's another step. This is listed in the FAQs that can be taken, and they're suggesting in these FAQs that to report any violations to the applicable regulatory authority for ERISA plans, the DOL, for non-ERISA plans, the No Surprises Act help desk. These are steps that should be taken in consultation with legal counsel. Hopefully you won't need to get to that step. Okay, so let's go on to the actual attestation of compliance and what this involves. So what's the process for submitting a gag clause prohibition attestation of compliance? And first, employers will need to coordinate with their insurers and other service providers. So we said that the insurer may be stating they're going to attest on behalf of the plan, but the employer wants to confirm that. They certainly don't want to assume that. And For other service providers, maybe the employer is entering a written agreement with the TPA to attest on the plan's behalf. So there is going to, as we've seen with other provisions, right, our pharmacy benefit reporting, there's going to need to be a lot of coordination, communication here. If the TPA or service provider will not submit the attestation on the plan's behalf, the employer is going to need to do so directly. And there is CMS, the Gag Clause Prohibition Compliance Attestation webpage that provides instructors and a user manual for this purpose. The good news is, from this with CMS, at least via email, we don't need to go through the registration with HIOS and all. The attestation is submitted through a CMS web form. And to access the web form, it's a pretty simple process. You know, the submitter, the party who's submitting the attestation, has to obtain an authentication code, and they would just go to the website, enter their email address. They're provided this code. I think it's a 6-digit code with about 10 minutes, and the code's good for approximately 14 days. If we just move to the next screen, and you see the shot of what you'll see when you go to that screen. Just enter your email address. Go on. And then what's the process? So the submitter would then log in with the code that's provided and follow the step-by-step directions in the user manual. They're also in step 2 of the instructions. So you're going to be entering data. It's data that should be in the plan's possession. Regarding the submitter, the party is entering the submission. The attester, that's the individual with legal authority to attest for the plan. In many cases, that's going to be the same one and the same as the submitter, just one party. Identification of the reporting entity, and that would be an ERISA plan that's considered a reporting entity. And whether the submission is for all provider agreements or just a particular type, such as a medical plan, maybe for behavioral plan, different, which contracts are you submitting for? So I think it's important to, our understanding here is that it's on a plan level basis that you're submitting the attestation, not on a contract basis. So after you go through the process, the submission of the attestation is the final step. And there's language that's included in the user manual. And the attester can't edit the attestation language. They have to just review it, electronically sign and submit it. And there is a confirmation that the submission was successful and a downloadable receipt. And it's a dashboard as well. One of the issues you'll see with the attestation language, because it's on this plan level basis and not contract level basis, is that it's requiring you to attest the submissions of the contract since December 27, 2020 to the present. And one of the questions that we posed, and one of our concerns is, well, what if your present contract is compliant to 2022 and you can't attest to 2021? And we've received different guidance on that. We would suggest that employers reach out to the service desk or email CMS. They've been extremely helpful, responding in 2 days. But one response they did receive was that you may be able to submit a comment to the effect that you can't attest for a particular contract, you can attest for the others. But the language in the actual attestation. If you want to move to the next screen there.
Yeah, I just want to pause really quick and just highlight that the phone number and the email are there we mentioned that earlier for clients, for employers to be able to reach out directly with those questions. Sorry.
Thank you. No, that's great. So here's the attestation language. So you can see it's saying, we're on compliance, since December 2000, our plan has been since December 27, 2020. And then you're going to, there's even a future component here, right? You're going to make sure that you're not entering agreements that fail to comply with these requirements going forward. So that's the attestation language, and there's really not a way to modify it, but it's something that we'll have to pursue further, whether a comment could perhaps be entered, if employers and their attorneys are comfortable with that, just to get through this initial compliance attestation, which I think is going to be the biggest challenge, like anything that's initially chased, right? That first one. And then we'll be seasoned veterans of it by next year.
Yeah, and also just a quick note that I know some people who just did the RxDC or prescription drug reporting might have a little bit of trauma coming out of that one. That this one is a little bit a lot more simple, right? We're not the process itself. So just calm nerves there. Take a deep breath. We're not talking about quite as difficult a process as that one was, but thanks for that.
Okay, some key takeaways. What should employer plan sponsors do now? Well, it's important to understand the gag clause prohibition requirements and the purpose. Review your applicable contracts for prohibited language, and I wouldn't delay. Because right now there's time. You have till December 31st. Let's not push it off, so it's a last minute scramble. Legal counsel likely need to be engaged in the contract review and revisions, any revisions that are necessary. Establish an ongoing process to ensure compliance, not a one-time deal, and then make sure that attestation is actually submitted by the December 31st deadline, and calendar this as something that you're going to have to submit going forward. If you're an employer who's going to need to submit the attestation directly to CMS, review the CMS resources, become familiar with the process. And then also you want to make sure as you're going into these new contracts that the service provider contracts reflect, who's submitting the attestation for this, make sure your contracts are compliant. And you also might want to consider, making sure that you have those other CAA and TIC requirements reflected in terms of the obligations of each party in the contract as well. And we do have a publication that highlights at a high level the transparency and CAA obligations of group health plans. You might want to ask for a copy of that as well.
Yeah, we've referenced a couple of publications. There's also obviously the primary publication for the gag clause prohibitions, but talk to your NFP account team representative to get a copy of that if you don't have it already, or for these other ones.
Okay, so what's NFP's role in the process? We're happy to share a new publication, toolkit if you don't have it already, and it outlines, what we've covered today. And just keep in mind, though, that while we're happy our role is educational, and we're happy to assist and share the information that we've learned. But again, we can't provide legal opinions, and we certainly can't attest on behalf of any plan with this particular contract. We just want to switch gears here quickly. What else is on the horizon here in our world of transparency? Well, we have this internet self-service tool requirement. This was under the transparency and coverage rule. We're already familiar, hopefully, with our machine readable files. And this is the other part of that rule, right? So we have this internet self-service tool is really designed for participants so they can comparison shop for healthcare services. And the idea is that they would receive, they call it like an EOB in advance. They would have personalized information about their out-of-pocket costs for covered healthcare items and services through an online self-service tool. Could be in paper if they specifically requested it. So it would provide like in real time what their costs would be, taking into account their current, what they've already applied towards their deductible out-of-pocket expenses. And there are certain requirements. It does have to be in plain language, indicate it's only an estimate. And when does this take effect? Well, part of it actually already took effect, but it was a phased in implementation. So it was only required for 500 common items and services for plan years beginning in 2023. But lo and behold, for plan years beginning in 2024, all covered items and services, includes prescription drugs or medical equipment, has to be included in this tool. Like the MRF requirements, carriers are subject to the tool, so fully insured plans can contract with the carrier to assume liability for the tool. Again, same setup with self-insured plans. They can track with that vendor. They're going to remain ultimately responsible for compliance. So it's a good idea at this point to check with your carrier TPA regarding the status as you're going into contracts, new contracts, maybe new providers. Keep that in mind so it's covered by the agreement, and just verify, that all is in order to for this to be fully launched and implemented by the 2024 effective date. And so you just might want to find some more information and see what resources they have maybe available to educate consumers about how they're going to be using this tool. It could be very helpful. Heidi, I know you're close to this this tool also. Do you want to speak a little about it in the time we have?
Sure. Let me just quickly, and I would refer you to your account teams if you have needs in these areas. But let me kind of compartmentalize between fully insured and I see a question about level funded versus self-funded. So fully insured, most of the providers have notified, but there's some inconsistencies in that notification as to whether they are providing, again, these self-service tools. Most of them are required to, but again, we're seeing some inconsistencies across the country. So just make sure that you talk to your NFP account team and make sure that if your employees or plan participants have not received any notifications, that in fact there's kind of a follow-up on that. The second being level funded. That's kind of a catch-all right now. So we're seeing, depending on the state that level funded plan is provided, it may not be a true ERISA qualified plan. If it is, let's assume that for a moment, that yes, you need to make sure that whoever you have that level funded plan through, whether it's the administrative services only through the carrier, that because you are an ERISA qualified plan, that you need to double check to make sure that those services are going to be provided. And if in fact there's going to be a charge associated with those additional services. The same is true of a self-insured plan or a self-funded plan, that if you're with the ASO provider, you shouldn't just assume that is being provided. Just get clarification that tool is going to be fully active January 1 of 2024, and the expanded requirements under transparency and coverage. We also, for independent TPAs, that you may just be leasing a network, but the claims adjudication is done by an independent TPA, that some of those providers are not providing self-service tools. So we have done some due diligence on a national basis and have some resources available to overlay on top of the plan that will meet those requirements. So please see your account teams and get further details depending on your circumstances.
Great, thank you. Just some final points in our last minute or two here. What should employers do now? We covered a lot. Just be aware of the upcoming deadlines for both the CAA Gag Clause prohibition attestation and the implementation of the TIC Internet Self-Service Tool. For the Gag Clause prohibition, please review our employer guide and act now to identify your plans and contracts subject to the prohibition, and reach out as necessary to carriers, TPAs, service providers to coordinate the attestation process. Again, for self-insured plans and fully insured plans without a carrier's attestation, the employer will need to review their contracts, gag clauses, and identify problematic provisions. Engaging counsel, again, we've emphasized that quite a bit. Once the contracts are compliant, the employer will need to submit their attestation in accordance with the CMS instructions. As Chase mentioned, we're seeing CMS who's going to put out a training session. I expect there'll be more. So that's something you might want to tune into as well. And for the Internet Self-Service Tool, reach out, as Heidi said, to carrier today to verify timely launching and inquire regarding educational materials. Heidi mentioned, and if we continue to develop cost and quality transparency tools to support these tools for participants. Employers should ensure also that their CAA and CSC obligations are addressed in any new contracts that they enter.
Right, and with that, I know we're at the very end of the hour here, and we did get quite a few questions. Many of those questions are answered in our publication or in the slides here. And so one final question, and I know this is not a great one. It is a great one to end on, but we don't have a great answer. But what about non-compliance and penalties? I know we can't speak to it directly because we don't know, but that's just a question that's come in a couple of times. What happens if we don't do this?
Sure. Yeah, we don't have any specific guidance. We often hear the $100 per participant per day, IRS penalty quoted. But I really think the point we want to emphasize here is that CMS really seems to be taking a very They're really trying to help employers comply. They understand that they're in a difficult position now, especially with these retroactive contracts. So I think good faith compliance is really important here. And if you run into a situation where you've done all you can and can't do any more, but you can't, test your compliance for the 3 years, I would say, speak with counsel, yes, but also, you might want to reach out to CMS and just just see if they can provide any insights. I think that from what we hear from industry groups and just our own interactions, that's the posture at this point. Obviously, we can't speak for them officially, but I think if you really make the effort, I think that's important to document what you do. And
Yes.
hopefully they won't we don't know how they're going to enforce it. Hopefully they, at least for this first go round, they're not looking to really to penalize employers who are really making an effort to comply. Obviously, if there's a willful disregard, if you don't make efforts and do everything you can, that's never going to be looked on favorably by any regulatory agency.
Right. So great words there to close, Carol. We're past our time here. Heidi, thanks so much for all your input, and thanks everybody for joining. We will circle up and take any unanswered questions and try and follow up with those. But if we didn't get to your question, please reach out to your NFP rep and we can get that answered for you and talk it through. But thanks everybody for taking the time. I'll flip it back over to you, Amber, to take us out.
Great. Thank you. Thank you to our speakers for sharing your valuable time and expertise with us today. To reiterate, today's presentation was recorded and we will be distributing the recording in the coming days. At the end of this call, a survey will populate in a new window. Please take a brief moment to complete the survey, as it lets us know what topics are important to our listeners and helps make our education program as current and relevant as possible. That concludes our webinar for today. Thank you everyone for joining us, and have a great day.